Hi, tonight, let's talk about some old stories from the history of LW and the distant Middle Ages. The law was very different from what we know today. It followed another kind of logic reflecting a world that is long gone. So, let's begin with our first story, a story about how the law used to see animals. In medieval Europe, the relationship between humans and animals was much closer than it is today. Livestock like pigs, cows, and horses often lived in the same areas as people, sometimes even under the same roof. Because of this, we can find court records from that time involving animals. It wasn't common, but it did happen, especially in parts of France and Switzerland. These trials can be separated into two types. The first type was handled by regular, secular courts and involved individual large animals, usually pigs, cows, horses, or donkeys. The charges were often for injuring or killing a person. The second type was handled by church courts and involved large groups of creatures seen as pests, like field mice, weevils, locusts, or caterpillars. Let's look at a relatively complete file from the secular courts of Falaise, France, from the year 1386. The document was written by the court clerk of the time, using iron gall ink on a sheet of treated calfskin. The handwriting is a late Carolingian script, neat but difficult to read. The file states that a sow, belonging to a local farmer named Perrault Legrand, was accused of entering the home of a villager, Jean Lubeg, one afternoon in January and fatally injuring his infant son. The infant's name was also recorded as Jean, the same as his father. The court hearing lasted for 9 days. The file includes the testimony of 3 witnesses. The first was the mother of the infant, who described the scene she saw when she returned from the fields. The second witness, a neighbor named Marie Ballard, testified that she heard the baby's cries and the pig's squeals. The third witness was the local butcher, who was called to give his opinion on the pig's aggressive nature. The file also includes a preliminary report on the infant's wounds, confirmed by a priest, which describes their depth and location. After the trial, a verdict was reached. The sow was found guilty of murder and was sentenced to death. The appendix of the file lists every single expense related to the case. For example, the temporary pen built to hold the pig used 7 oak posts and 3 bundles of rope, and the carpenter's labor cost 4 sous. During its 11 days in custody, its daily feed was precisely recorded as half a bushel of mixed grains, mainly oats with a small amount of barley, and a bucket of well water, costing a total of 12 sous. The executioner, a man named Jacques Gallet, was paid a fee of 54 sous for carrying out the hanging and disposing of the body. There was also one more curious expense: 7 sous for a set of human clothes for the pig. The set included a waistcoat made of rough cloth, a pair of pants, and gloves. These details were carefully written down, becoming part of the judicial process of that time. Besides these cases involving large livestock, the church archives hold records concerning agricultural pests. For instance, in the 15th century region of Lausanne, local vineyards were suffering from an infestation of weevils. The villagers asked the church for help. The church responded by beginning a religious legal process. They would first send a priest to observe the fields and confirm that the damage was indeed caused by weevils. Next, the church court would draft a document, known as a warning. In this document, in the name of the Father, the Son, and the Holy Spirit, the creatures would be warned to stop their destructive behavior and to leave the lands of the parish within a set period. This document would then be read aloud 3 times in the open fields by a court official, each reading accompanied by the ringing of bells and prayers. This was an ancient attempt to influence the natural order through religious ceremony. These records about animals reflect a worldview of that time, where even the smallest creatures were thought to be part of a larger, sacred order. So, what happened when the one disrupting this order was a human, and there was no direct evidence? How did the courts of that time seek what they believed to be the truth? They chose a method that placed the final judgment in the hands of a divine power. This method, in history, is known as the trial by ordeal. Trial by ordeal was an ancient judicial practice. Its core idea was that, through a physical test, God would reveal whether the accused was guilty or innocent. This test had strict religious rituals and procedures. One type of test involved fire. Liturgical books from the period describe the preparations for a trial by fire in great detail. For 3 days before the trial, the accused had to fast, drinking only water and eating small amounts of bread. Each day, they had to attend morning and evening prayers at the church. This process was seen as a purification of the body and soul. On the day of the trial, the presiding priest would hold a special Massachusetts. He would sprinkle holy water on the iron bar or plowshares that were to be used, and recite a long prayer. The prayer would ask God to show his justice, to protect the innocent from the flames, and to reveal the guilt of the wicked. The words of the prayer were often taken from the Psalms, filled with calls for divine power. After the test, the accused hand would be immediately wrapped in linen cloth treated with holy oil and sealed with the church's wax seal. 3 days later, the seal would be broken in front of witnesses, and the wound would be inspected. If the wound was healing cleanly, without infection, it was seen as a sign of innocence. But if it was festering, it was seen as a sign of guilt. Another common test involved water. This was known as the trial by cold water. The pond or river to be used was also blessed beforehand. The accused hands and feet would be tied, often with the right thumb tied to the left big toe, to limit struggling. Then he or she would be slowly lowered into the water. It was believed that the pure, blessed water would reject an impure, guilty body, causing it to float, but it would accept a pure, innocent body, allowing it to sink. Of course, a rope was usually tied around the accused waist, so they could be pulled out in time if they were found to be innocent. The entire process was carefully documented. This judicial practice began to decline after the Fourth Lateran Council in 1215. The Church issued a decree forbidding clergy from participating in such activities, believing it was a way of testing God. After this, trial systems based on evidence and investigation slowly became the mainstream in European law. The Church's ban caused trial by ordeal to slowly fade from history. But for the secular nobility and the warrior class, they had another tradition for settling disputes. A tradition that was about honor and also about strength. When two parties could not agree, and their words were in conflict, they believed that a fair fight could reveal the truth. Because God, they believed, would grant victory to the side of justice. This method was known as trial by combat. Trial by combat, or judicial duel, was a legally recognized formal procedure for resolving disputes. It can be found in Germanic law codes, such as the Salic law, and it was widely used in medieval Europe, especially in France and the Holy Roman Empire. It had a strict set of rules and ceremonies, and was not a simple private brawl. To begin a judicial duel, several conditions had to be met. First, it was usually reserved for serious criminal accusations where there was no direct witness or physical evidence. Second, the plaintiff and defendant had to be of similar social standing, typically free men or nobles. A serf had no right to challenge a nobleman to a judicial duel. The case would first be heard by a local or manorial court, and only when the judge confirmed that a verdict could not be reached by conventional means would a duel be approved. The dueling ground, known as the lists, was a flat piece of ground that was carefully marked and prepared, often in a castle courtyard or a town square. The dimensions of the field were strictly regulated. For example, a French legal document from 1306 specified that a dueling field for combat on foot should be 80 paces long and 40 paces wide. The field would be enclosed with wooden fences or ropes to separate the inside from the outside. A court official, known as the marshal, was responsible for overseeing the preparation of the field and inspecting the weapons and armor of both combatants. The weapons used by both parties had to be equal. In early duels, the common weapons were the longsword and the kite-shaped shield. By the late Middle Ages, as armor technology advanced, full-plate armor became standard for duels among the knightly class. A complete suit of 14th-century Gothic plate armor consisted of dozens of components, including the helmet, breastplate, pauldrons, vambraces, gauntlets, cuisses, and sabatons, with a total weight of 20 to 25 kilograms, or about 45 to 55 pounds, offering excellent protection to the duelist. The choice of weapons also became more diverse. Besides the longsword, long-handled poleaxes, war hammers, and a type of polearm known as the poleaxe were often used. Before the duel, these weapons would be presented to the marshal for inspection to ensure their length and weight met the regulations, and that they were not coated with poison or enchanted with illegal magical charms. Both combatants were also searched before entering the lists to prevent them from carrying hidden daggers or other backup weapons. When one of the parties in a lawsuit could not fight in person, such as a woman, a child, an elderly person, or a member of the clergy, the law allowed them to appoint a champion to fight on their behalf. This gave rise to a profession. Champions were professional mercenaries, skilled in combat, who made a living by participating in judicial duels. Hiring a famous champion was extremely expensive. This also caused the system, in its later stages, to gradually move away from its original purpose of seeking divine will, turning it into a contest of wealth and power. If a champion lost, he himself could sometimes be punished, for example, by having a hand cut off, to show that he had failed to defend justice. Over time, and with the strengthening of central monarchies, the practice of judicial duels was gradually replaced by trials in state courts. Monarchs preferred to concentrate judicial power in their own hands, rather than allowing nobles to resolve disputes through force. By the early modern period, the judicial duel had largely disappeared from official legal procedures. Whether by the flames of an ordeal or the sword of a duel, the subjects of these trials were, at least, living beings capable of feeling and responding. But the archives of history also record a much stranger trial. Its defendant was a bishop who had been dead for more than 7 months. His body was taken from its grave and brought into the courtroom. This event, in history, is known as the Cadaver Synod. This trial took place in Rome in the year 897. At that time, the papacy was experiencing a period of intense internal political strife. The chief judge of the event was the reigning pope, Stephen VI, and the defendant was his predecessor, the deceased Pope Formosus. To understand the context of this event, we must first look at the political environment of the Roman papacy in the late 9th century. The power of the pope was heavily influenced by local noble families, especially the long-standing rivalry between the House of Spoleto and the Counts of Tusculum. The election and removal of popes were often the result of the political maneuvering of these families. The central figure of the event was Pope Formosus. He reigned from 891 to 896. He was an experienced diplomat, but in his political stance, he tried to break free from the influence of the Spoleto family, who controlled Rome at the time. He instead sought the support of Arnulf of Carinthia, the king of East Francia, and crowned him Holy Roman Emperor in 896. This act was seen by the Spoleto family as a direct betrayal. The other main figure was Pope Stephen VI. He became pope shortly after Formosus's death in 896, with the strong backing of the Spoleto family. He also held a personal grudge against Formosus. Earlier in his career, Formosus had appointed Stephen as a bishop, but may have later removed him for political reasons. Therefore, after Stephen VI took power, his primary task was to completely undo the political and reputational legacy of Formosus. In early 897, Stephen VI ordered that the body of Formosus, who had been buried for over 7 months, be exhumed from his tomb in St. Peter's Basilica. According to the chronicles of Liutprand of Cremona, the decaying body was dressed anew in full papal vestments. These vestments included the white alb, the red chasuble, and the tiara, the triple crown symbolizing papal authority. The body was then transported to the Basilica of St. John Lateran and placed on a throne in the courtroom. The trial began. Stephen VI presided personally and brought forward a series of charges against Formosus. The main charges were perjury, for allegedly breaking an oath never to return to Rome but eventually becoming its bishop; ambition, for having sought the papacy through improper means; and violating church law by transferring from one bishopric to another. The court appointed a young deacon to stand behind the silent corpse and answer the questions on its behalf. Detailed records of the questions and answers from the trial have survived. In the end, Formosus was found guilty of all charges. All of his papal decrees and clerical appointments were declared invalid. A symbolic punishment was then carried out on the body. Soldiers stripped the papal robes from the corpse and cut off the 3 fingers of the right hand that he had used for blessings, the index, middle, and ring fingers. Finally, the body was dragged away by a crowd and thrown into the Tiber River. This event caused a huge uproar at the time. The citizens of Rome were outraged by the disrespect shown to the dead, which eventually led to a riot. Pope Stephen VI himself was overthrown, imprisoned, and eventually strangled. This trial, therefore, became a dark symbol of how extreme power struggles can become. We have just reviewed some of the systematic judicial practices that existed in specific historical periods. Though strange, they all had their own internal logic and rituals. Before we conclude our long historical review, let's look at some miscellaneous legal rules, scattered across different times and places. They may not be as systematic, but they also offer us a glimpse into the daily life of the past. Besides dealing with major crimes and disputes, the law has often been used to regulate the small details of daily life. These rules can often tell us a lot about a society's customs, economy, and unique cultural ideas. In ancient Rome, there were rules about the colors of clothing. This was part of what were known as sumptuary laws or laws against luxury. The restrictions on Tyrian purple were especially strict. This dye, extracted from a small sea snail called the Belinus brandaris, was extremely difficult to produce. According to the Roman naturalist Pliny the Elder, the dye was worth 10 to 20 times its weight in silver. Because of this, purple became a symbol of wealth and status. Roman law specified in great detail the dress code for citizens of different classes. For example, members of the equestrian class could wear a narrow purple stripe on the hem of their togas. The purple stripe for members of the Senate could be wider. And a toga made entirely of purple fabric, during the imperial period, was established as the exclusive privilege of the emperor himself. This rule was meant to stabilize and display the social hierarchy through visual symbols. In late 17th century Russia, Tsar Peter the Great introduced a series of reforms aimed at westernizing the country. One of these was the beard tax decree, issued in 1698. Before this, the Eastern Orthodox tradition viewed beards as a sign of masculine piety. Peter the Great, however, saw long beards as a symbol of Russia's backwardness. The decree required all town residents, except for clergy and peasants, to shave their beards. If someone wished to keep their beard, they had to pay a tax, with the amount varying based on their social status. For example, a wealthy merchant had to pay 100 rubles a year, while a common townsman paid 30 kopecks. After paying, they would receive a copper or silver token as proof of payment. This token was usually inscribed with the Russian words for "the tax has been paid" and "a beard is a useless burden." In many late medieval European cities, strict regulations were enacted concerning building materials and the use of fire at night to prevent fires. For example, in London in 1212, the mayor issued an ordinance requiring all new houses to have roofs made of tile rather than flammable thatch. The ordinance also required every household to keep a barrel of water outside their door in case of emergency. Furthermore, after the curfew bell rang, all bakeries and breweries were forbidden from using their ovens, and violators would be fined heavily. These early fire safety laws reflect the immense fear of fire in the crowded, wooden-structured cities of the time. In some ancient Greek city-states, the law would even involve a citizen's marital and military obligations. In Sparta, to ensure the city-state had a sufficient supply of strong warriors, male citizens were required to marry at an appropriate age and have children. If a man remained unmarried for a long time, he could face social criticism and some form of punishment. Similarly, in medieval England, to maintain its powerful force of longbowmen, there was a law requiring male citizens of the freeman class to practice archery on Sundays and holidays, while forbidding them from playing other games like football. These rules all show the classical idea that an individual's life was expected to serve the collective interest of the city-state or the nation. These ancient law books, these old rules, are like pebbles in a riverbed, their sharp edges worn smooth by the flow of time. They were once a hard reality. Now, they are just a distant echo, lying silently in the long river of history. Now, let these distant and faint sounds slowly drift away, and let your thoughts also slowly become empty. Feel the relaxation in your body, from your fingertips to your arms and to your shoulders. All the tension is slowly dissolving. Just as these ancient laws eventually fell silent, your consciousness is also about to enter a state of quiet, peaceful rest. Good night, and may you have a deep and dreamless sleep.